Subcommittee will come to order. Fairly short meeting today. As usual, please silence your cell phones. If you want to speak against a regulation, you need to sign up at the sign-up sheet at the back ahead of the meeting. First matter of business is approval of the minutes. Are there any additions or corrections to the minutes? Seeing none. Before we approve any motion, we need to call the roll first. Please call the roll.
Senator Rocky Adams, Senator Thayer, Senator Yates, Representative Bridges, Representative Frazier Gordon, Representative Grossberg,
Present.
Senator West,
Here.
and Representative Lewis.
Here.
We have a quorum.
Back to the minutes. Is there a motion for approval of the minutes?
Second.
We have a motion and a second. Without objection, it is so ordered. Please call the first regulation.
Education and Labor Cabinet, Education Professional Standards Board, 16 KAR 4020 with staff suggested amendment.
Microphone.
There it is. This regulation is being amended to update terminology. The staff suggested amendment makes technical corrections and clarifies existing language for consistency with the amendment.
Would you please identify yourself for the record?
Good afternoon, Cassie Trueblood, Counsel for the Education Professional Standards Board.
Thank you. There is a staff amendment. Is there a motion for approval of the staff amendment?
Second.
We have a motion and a second. Without objection, it is so ordered. Any questions from members of the committee? Seeing none, please call the next regulation. Thank you.
Finance and Administration Cabinet, Kentucky Public Pensions Authority, 105 KAR 1390 and 455, both with agency and staff amendments, and 105 KAR 1470 with staff suggested amendment.
105 KR 1390 amends to make technical changes, update definitions, make changes to reflect House Bill 506 from the 2023 regular session, including changing the break-in employment requirement for any member retiring after January 1, 2024 to 1 month, and update material incorporated by reference for clarity and to add a legal certification statement. 105 KR 1455 establishes definitions, procedures for filing an application or reapplication, procedures for total and permanent in-line of duty hazardous disability retirement benefits, appeal procedures if denied, and material incorporated by reference. 105 KR 1470 establishes definitions, how the KPPA is required to communicate with members, retired members, beneficiaries, alternate payees, and other recipients of retirement allowance, procedures to change communication preferences, and change of contact information form. The staff amendments for 105 KR 1390, 455, and 470 all make changes to comply with KRS Chapter 13A. The agency amendment for 105 KR 1390 amends Section 4 to clarify the agency may also consider rules issued by the United States Department of Labor for determining whether a worker is an employee or independent contractor under federal wage and hour law, and amends Sections 4, 5, and 7 for clarity, including to change cross-references. The agency amendment for 105 KR 1455 amends Section 1 to add a definition of medical examiner, amends Sections 6 and 7 to specify the medical examiner is the only third-party vendor that can order an independent evaluation by relocating language, amends Section 14, which had duplicative language, and combined and condensed language to be more concise, and amends various sections for clarity and to comply with KRS Chapter 13A.
Would you please identify yourself for the record?
Carrie Bass, Staff Attorney Supervisor for the Kentucky Public Pensions Authority.
Jessica Bobian, Policy Specialist for Kentucky Public Pensions Authority.
Thank you so much. There are staff amendments. Is there a motion for approval of the staff amendments? We have a motion and a second. Without objection, so ordered. There are also agency amendments. Are there any questions on the agency amendments? Seeing none, is there a motion for approval of the agency amendments? There is. Without objection, it is so ordered. So you have before you the regs, Public Pension Authority regs as changed by staff amendments and agency amendments. Any questions from members on this set of regs? Seeing none, please call the next regulation. Thank you.
Department of Military Affairs, 106 KAR 131, with staff suggested amendments.
This regulation is being amended to add a definition section and update the processes and procedures for noncompliance. The staff suggested amendment amends various sections to comply with the drafting and formatting requirements of KRS 13A and make technical changes.
Would you please identify yourself for the record?
Charlotte Sands, Counsel, Department of Military Affairs.
Corey Ann Jackson, Legislative Liaison, Department of Military Affairs.
Thank you. There are staff amendments. Is there a motion for, I apologize, there is a staff amendment. Is there a motion for approval of the staff amendment? We have a motion. We have a second. Without objection, so ordered. Any questions from members for the Department of Military Affairs? Seeing none, thank you. We'll take a brief pause. We had to call an audible in the committee here. Just want to let everybody know that the Board of Social Work Reg 201KR 023170 will be heard last today. So we'll skip over that briefly, and we will hear that at the end. Thank you.
Thank you.
Boards and Commissions, State Board of Accountancy, 201 KAR 1200, with staff suggested amendment.
201 KR 1200 identifies and establishes, pursuant to House Bill 275 from the 2022 regular session, the criteria for the scholarship program supported by the board, which is the educational foundation of the Kentucky Society of Certified Public Accountants, with donations to the foundation having the same qualifications as regular foundation activities, except that the board's scholarship funds are only available to applicants who are enrolled in a Kentucky-based college or university. The staff suggested amendment amends various sections to comply with KRS Chapter 13A.
Would you please identify yourself for the record?
Yes, good afternoon. I'm Joe Donahue, the Executive Director of the Board of Accountancy.
Thank you. There's a staff amendment. Is there a motion for approval of staff amendment? We have a motion and a second. Without objection, so ordered. Any questions for the Board of Accountancy? Seeing none, thank you. As stated earlier, we will now move to General Government Cabinet, Department of Agriculture.
So 302 KAR 45020, with staff suggested amendment.
302-45020 establishes a pilot program for ginseng plants and seeds. The staff suggested amendment amends various sections and incorporated material to comply with KRS Chapter 13A.
Would you please identify yourself for the record?
Clint Quarles, Counsel for the Department.
Anna Lucio, Marketing Specialist for the Department.
There's a staff amendment. Do we have a motion for approval of the staff amendment?
Second.
We have a motion and a second. Without objection, is so ordered. Co-Chair Lewis has a question.
Yes, can you tell us a little bit about the pilot program?
Yes, sir. The pilot program was created because we have a vacuum between the normal harvest period and rules about holding ginseng out of season. The pilot program's established so that we can create a native source of seed and planting material for people, farmers, gardeners, anybody else that would like to possess those plants outside of the normal growing season. And then Anna's got more.
This also helps us. Kentucky is considered the largest traditionally wild producing ginseng state, and there's a lot of folks that want to farm this as a crop. And in order them to farm it as a crop and identify it for all the benefits that a typical crop would be, this program helps us establish and look at what is successful or not successful to do so. So that way they can also get those programs that are like specialty crop grants or insurance programs or just anything that identifies them different than a wild crop. And eventually we hope that will help us provide some source verification for a sustainable ginseng root that is different than a wild product, so we can continue our industry for the future.
Very good. Thank you.
Any other questions for the Department of Ag? Seeing none, please call next regulation. Thank you.
Division of Waste Management, Special Waste, 401 KAR 45 10, 20, 25, 30, 40, 50, 80, 100, 105, 140, 160, and 250, all with staff suggested amendments.
401, 45010 through 250, amend provisions for special waste to create distinct and separate requirements for biosolids. 45010 amends definitions. Amendments to 45020 through 100, 140, and 160 primarily remove provisions for biosolids and make technical corrections. 45105 establishes standards for the land application of biosolids. 45250 amends permitting fees for special waste to include biosolids. 45105 was amended after comments to amend sections 2 and 3 to make technical corrections, amend section 2 to clarify biosolid exemptions, amend section 3 to establish that biosolid land application notification shall be in writing and occur prior to application with the cabinet, amend section 5 to clarify provisions pertaining to aquifers, revise incorporated material, and amend section 7 to require the cabinet to post permit issuance on its website, provide an appeal process related to permit issuance, and establish that biosolid land application shall not commence until 30 days from public notice of the permit issuance. 45160 was amended after comments to make technical corrections. The staff suggested amendments amend various sections to comply with KRS Chapter 13A and authorizing statutes.
Would you please identify yourself for the record?
Mr. Chairman, members of the committee, I'm Tony Hatton, Commissioner of the Kentucky Department for Environmental Protection.
My name is Michael Mullins. I'm an environmental scientist consultant with the Commissioner's Office.
Thank you. There are staff amendments. Is there a motion for approval of the staff amendments? We have a motion and a second. Without objection, it is so ordered. Are there any questions for the members of the cabinet? We do have someone signed up to speak against, and so we'll come back to them later, but any questions right now from members? Seeing none, we have Mr. Fitzgerald here to speak against. As soon as you are settled, state your name for the record and proceed.
Mr. Chairman, thank you. Tom Fitzgerald. I'm of council, former director of the Kentucky Resources Council. It is good to see you all. Just when you thought it was safe to come to the committee room and that you were going to have a short meeting, I show up. I'm here to ask you to attach a letter of deficiency to this set of regulations because they fail to protect farmers, farmland, and the public from the land application of contaminated sludge from municipal treatment plants. You'll recall during the last session you enacted Senate Bill 213. There were some complaints from a couple of the cities regarding the way that the cabinet was managing land farming or land application of sewage sludges, which are called euphemistically biosolids. The cabinet was directed to adopt standards, quote, in conformance, end quote, with the Section 503 regulations, which are federal regulations that are self-implementing regulations that require monitoring for 9 metals prior to land application. They also cover sludge disposal in incinerators and some other things. But in 2018, the Inspector General, which is within the Environmental Protection Agency, looked at their sludge regulation program and said, based on the data that you, agency, have collected since 1989, there are over 350 other contaminants of concern, including 61 designated as acutely hazardous or priority pollutants that you're not sampling for, and you should be sampling for because your regulations, as we view them now, are not protective necessarily of human health and the environment. The agency didn't disagree and indicated they were going to go forward and to address this, but they have not to date. My concern is heightened by what has happened in Maine, and you're probably aware of the fact that the land application of contaminated sewage sludges there led to catastrophic losses for some farmers who had taken these sludges, thought that they were applying something that was beneficial to their crops and to their cropland, and ended up contaminating them with these so-called forever chemicals, PFAS, that the federal government is now moving to regulate. My concern is that before cities offload, either by sale or by giving sewage sludges to farmers for use as fertilizers, that there be a requirement that they adequately test them to make sure that the farmers are not getting something that is going to contaminate their land, require them to pay long-term cleanup costs under state or federal Superfund laws, and which are going to damage their farmland, their crops, or the animals that are foraging on what is being raised there. The only thing under this set of regulations that the city must tell the farmer is that, quote, biosolids may contain constituents from an industrial pretreatment program, end quote. You're probably aware industrial pretreatment programs are required for municipalities where they have a certain industrial throughput, where industries are discharging their pollutants in addition to residences and commercial establishments, all discharging into the same sewage treatment plant, which then clarifies and treats the sewage and ends up with these sludges. The phrase biosolids may contain constituents from an industrial pretreatment program. Well, with all due respect, constituents are the people that are in your districts. Okay, what we're talking about is pollutants. We're talking about contaminants. We're talking about things that, if they are not properly tested and they are applied to land, can contaminate the land, can contaminate the crops, can sicken or kill the cattle. That is what's happened in Maine that caused them to now ban the land application of these wastes. Are they going to be in all the waste? No. But a farmer has a right to know what is in the constituents, and we have an obligation, I think, to require that before the cities use land application as a way of disposing of these wastes, that they test them adequately and screen them to make sure that the farmers who are looking for an alternative to pretty costly chemical fertilizers are not being saddled with the long-term contamination of their farmland. At a minimum, if we're not going to require testing, we need to revise this statement that is given to the farmers to say, you are on your own, since we have no idea whether the forever chemicals or other chemical constituents are in the sludge, and we don't intend to test for it. Until, members of the committee, you are presented with a set of regulations that require screening for these contaminants and full disclosure to the farmers so that they can make informed decisions on the risks and the benefits of using sewage sludge as a agricultural amendment, I would ask that you find these regulations to be deficient, so that if the regulations do go forward, they will go forward only on the governor's determination that the interests of the cities in disposing of these sludges on the cheap is more important than assuring protection of farms and farmers and the food supply. Thank you, and I'm happy to answer any questions that you have. I did, Mr. Chairman, send, and staff was kind enough to ask if there were materials to send, and I sent, I think, last Friday, and you may have received them. I know that you've got 1,000 things to read, so you may not have had a chance to look at them, but the Inspector General's report from 2018 details the deficiencies in the federal regulations, and there's really a need at this point to look at some of these emerging contaminants rather than to allow these sludges to be land applied without anybody doing any screening on the contaminants that may be in there. So happy to answer any questions that you have and appreciate the indulgence of the committee, the ability to be here and speak on this.
Thank you so much. Before I accept questions, I'll just allow the cabinet to respond if they have any response to that.
Well, as Tom has mentioned, it's been a long-term process for POTW biosolids to be either land farmed or land filled, or maybe even other beneficial type uses. We know now in the Commonwealth of Kentucky that the majority, and that's not to set aside the issues Tom's raising at all or to diminish what he's saying, but in the majority of these cases, cities are looking at the landfill option for their biosolids. Biosolids is not a waste that you can elect to quit generating. And so cities generate it as a service to the public. So they have to have something to do with it. The issue that's gotten complicated over the last 3 years is that landfills may experience operational problems when they take significant amounts of sludge, which we're all aware of, that might relate to the early generation of odors and structural problems in a landfill. And so in the last 3 or 4 years, I think more and more cities have had to look back at the land farming option. Now, to be for sure, emerging contaminants, and as Tom mentioned, there may be other industrial contaminants as well, but emerging contaminants has certainly started to bring this issue to the forefront. When we look at what the statute required us to do, which was to prepare a set of regulations in conformance with 503, and we worked to get siting criteria and the necessity of a permit in there, we feel like within what the statute authorized us to do, that we fulfilled that responsibility. Now, I've known about PFAS issues for quite a while now. The agency is actually doing a lot of work related to PFAS. I'm not going to go into that, but if anybody's interested, we're doing a lot of investigative work. We're doing some volunteer sampling for POTWs that want to let us do that. But I took what I thought was the next step in where I think biosolids land management is going to go, especially as the federal government catches up. And because I think they will at some point. EPA has been a little slow in coming out with federal regs. Some of their dates they're missing and passing. They've yet to file the drinking water standard, which we've been waiting on for a while, which right now is our primary concern. That's why we're doing a lot of drinking water facility sampling and private domestic use well sampling. But the notification process, as Tom's pointed out, issues that may have with that, or it falls too short. The express purpose that we put that in the reg was to start sort of the process moving down the road that this is going to become more complicated as time goes on. At the same time, I didn't feel like we had the statutory authority to preclude or to require sampling or set a standard for a substance that's not yet regulated in the Commonwealth of Kentucky. So also in 503, there are parts of 503 that are considerably, I would say, are considerably more restrictive than even our current regulatory package. In essence, emerging contaminants and industrial contaminants in biosolids are not considered under our current regulations, and they're not specifically considered under the 503. But 503 does give the agency discretion that on a case-by-case basis that we can require sampling, different disposal options as information arises that we might think is necessary to protect human health and the environment. The fact of the matter is we have a lot of data, a lot of information. We've gained a lot of knowledge about PFAS in the state, where it's at. In some cases, what we have found, for instance, if you have like an industry code where the EPA says this industry is likely to be related to PFAS, through our ability to go out and sample, we've done a lot of what I call ground truthing. We've gone to state-lead dry cleaner sites. We've gone to the old orphan landfills, metal plating operations, and places like that where we had monitoring points in place and we've sampled. And what we have found is that generally most of those types of facilities or features on the SIC code, there is likely to have been impacts from PFAS to groundwater. 503 doesn't have provisions for groundwater. I put some provisions in there that I thought could defend, like sensitive areas of the state where you have sensitive groundwater regimes, like the Purchase area, the Ohio River, Louisville Valley, and that karst corridor down I-65. So we know and fully understand those implications, and perhaps some of the implications where the federal government may at some point, or at least they intend to list certain PFAS substances as hazardous substances under federal Superfund law. Now, what that ultimately means is that at least the way Superfund works is that anybody who generates it, arranges for the transport of it, and stores or disposes of it might have future liability under federal Superfund law. That is an issue that's being hotly debated right now because the questions have been asked is, should a farmer be excluded from that? And typically, no one's excluded from regulation under CERCLA. That is probably maybe the most impactful federal rulemaking that may come down the pike from a potential liability and programmatic really very difficult to fix. So some of the issues that Tom's raised, we've been aware of them for a while. We prepared a reg we thought was in accordance with what our statutory mandate was in Senate Bill 213. And I'd be glad to try to answer any questions that you all may have of the agency.
Thank you so much. I've got a few questions, but I'm going to yield to other members first and see if they have any. Do we have any other questions from members? Representative? And I always want to say Representative Frazier, but it is Frazier Gordon.
Thank you all for being here, and it's obvious that you all have expertise in this area, and so I appreciate you seeing each other's viewpoints and trying to work together. And I think just from listening to the synopsis that both of you provided, that perhaps Mr. Fitzgerald may have offered the perfect solution, which would be just at least a notice or a disclaimer that goes to the property owner. So at least there's a where, and then maybe as these things develop, as far as what the federals do and the screening that's offered in some situations. I just kind of wanted to make that comment.
Co-Chair Lewis.
Thank you. Fitz, it's always good to see you. Appreciate your input. I know we all end up on opposite sides often, but I always appreciate your perspective and the work you put in. To the commission first, did the EPA weigh in on any of these regulations?
No, the 503 federal regulation is they're weighing in on this regulation. It's a self-implementing program, as Tom pointed out. One of the things we did in our regulation, because the statute required us to do it, is we added siting criteria that's not in 503, and we added the necessity of getting a permit, which is not part of 503. But otherwise, EPA would really have, if EPA at one point wants to really weigh into the 503 situation, they would need to update their federal regulations to include some of the emerging issues that they're looking at regulating at every other stop along the road right now. But that's yet to happen. I don't know when that'll happen. I know they said they're working on a risk assessment for PFAS and biosolids. Last I heard, end of calendar year 24, mid 25, based on conversations I had with the regional administrator. But no, the short answer, Representative Lewis, I'm sorry if I was a little too long. No.
Thank you. One more question, Chair, if you'll indulge me.
Please proceed.
So, the purpose of this committee is to make sure that the regulations being passed are in accordance with 13A on the basis of deficiency. Looking over the bill and it being Senator Higdon's bill, it seems like it was a combination between his work and KLC and the cabinet all working together. That being said, when I review this, I don't see a basis for deficiency, but I do see an opportunity to maybe pass future legislation to help protect our farmers. Fitz, would you like to speak on that?
It's great to see you also, and thank you for that question. The Cabinet's authority for adopting regulations is not limited to Senate Bill 213 and to the statutory changes that it affected. They have a broader mandate that is in Chapter 224. That's the mandate that drives all of their activity. The 503 regulations, as Tony mentioned, as the Commissioner mentioned, allows for case-by-case addition to the requirements of the 503 regulations where there is reason to impose those. I believe we're at that point. We have reason for any sewage treatment plant that has a pretreatment program. We've got 7 years of data that the Inspector General's office looked at, that EPA itself collected, showing that there are over 350 contaminants that are not currently being regulated. The agency has said that they need to move forward on those and to determine whether additional controls need to be done. I think we're at that point where the bare minimum we need to do in order to protect public health and the environment, which is the Cabinet's overarching mandate, and there's nothing in Senate Bill 213 that restricts that mandate, is that we should require broad spectrum testing of the cities for the sludges before they're released for land application. And we ought to, as Representative Frazier Gordon noted, we should improve the notice that's given You know, every year I get a notice in my mail from the Louisville Water Company of everything that they've tested for and what the actual levels are, so I can make an informed decision about whether I want to drink the water, right? A farmer who is land applying these wastes, as we learned catastrophically in Maine, because there you had farmers bankrupted, their entire cattle herd destroyed because they were contaminated, and their farmland ruined for how many generations because of these forever chemicals. We need to make sure, because we know that they're an emerging contaminants of concern, we need to make sure that the farmers are aware that the sludges that they're taking may or may not subject them to long-term liability as well as short-term problems with the operation. And I think that providing clear notice of what is and what isn't, you know, if we're not going to test, let them know that this has only been tested for 9 metals and has not been tested for a range of chemicals that are discharged into the sewage system that this sludge is coming from. But I do think they have the statutory authority. If you look at the general authority that they have under KRS 224, Chapter 10, that provides them the authority to adopt standards for waste management and protection of public health, safety, and the environment.
Thank you. Thank you, Chair. Representative Bridges.
Thank you, Mr. Chair. There are just a couple of things that popped up as y'all were talking, both sides. Do either one of you have any kind of estimate of what the costs incurred would be for either random testing or the additional items to be tested for, anything?
Representative Bridges, I probably couldn't give you a real good idea on what a full suite of 300 plus parameters might be, but I have seen numbers for sludge analysis for PFAS, which is a little more complicated than analyzing a liquid sample, anywhere from the $2,500 to $3,000 range. One of the things we did a few years ago when we realized this was coming is we availed ourselves of equipment in our DEP lab. We have a small lab, but it's a very good lab. And so we knew that we had to learn a little bit more about what we had in the state, and we knew we couldn't afford to do it if we had to contract and pay third-party lab fees. So we've developed that process for sampling sludge. And like I said, we have volunteered our services to POTWs who are interested in having their sludge sampled at our cost. Now, the reality of it is a media like sludge, maybe one sample doesn't necessarily tell the whole story. I mean, because it can be significant differences. Where we sampled it in groundwater, we see it pretty steady. But yeah, it's not necessarily a cheap analysis, and you have to be very careful how you collect the samples. We have specific standard operating procedures for sampling PFAS that you don't have for other types of constituents we sample, because there are so many things, you know, Scotch Guard seats in the vehicle, you know, particular things on your clothing that can actually introduce PFAS to a sample when it wasn't really there. So we've gone to a pretty great degree to develop SOPs and things like that. So that would also carry forward to someone who's having to do that or contracting, having it done. Because the reality of it is, if you collect a sample and you're not sure whether your process might have affected it, there's a lot that rides on what comes out of the end of a machine. Decisions are made based on that. But $2,500 to $3,000 is probably reasonable for now for sludge samples.
One more question.
Please proceed.
How would that compare to the cost of cities that were unable to give this sludge away and have it, you know, on these farms? What would the cost of putting that in to continue the way it is without, you know?
Well, I can't really, I can maybe say on a per sample basis, but I'm sure that given the fact that sometimes discharges into a POTW ebb and flow, to really be accurate about it at any point in time, it would probably require periodic sampling in a type of material that can change so much because inputs into it might change. In other words, it's not a static condition. I think at some point that might have to be weighed against the cost of looking at a different option, like the potential to landfill it. Currently,
and that's what my question is.
Yes.
You know.
Yes. or have some type of on-site facility, which is probably not feasible for a lot of small cities, to build a disposal facility that has, groundwater protection measures in place. On paper, that works, but that's probably not a viable option, especially for smaller municipalities. That's really the two options they have now is land farming and land filling. Most of them landfill it. Some still have land farm operations going on. I will point out that we have not gotten a permit application for a new land farm application in 2 years. That was a concern that was raised early on. We've not seen any new applications, even under our current regulations. So I'm not sure why the significance of that, but maybe time will tell. I hope I answered your questions, Representative Bridges.
Representative Bridges, if I could just follow up very, very briefly, uncharacteristically briefly. The costs that you're comparing, there's a third set of costs that really need to be looked at. Because if I have a municipal sewage treatment plant, I have at least a fairly good sense of what industrial sources are discharging into it because I have a treatment program and I'm requiring them to do some sampling and require them to report levels of contaminants that are coming into the system. The question remaining is what is partitioning out into the sludge as opposed to what is going out into whatever the river or stream that I'm discharging. But the third set of costs you need to look at is what would it cost a city now? Because they have to get rid of the sludge. Other people are contributing it. They're responsible, for managing it. And we all understand that. But the other cost is, what is the cost going to be to that farmer if the land gets contaminated and they're later required to clean it up? What's the cost going to be to the city if they get a bill sometime in the future that says, your sludge ended up on this farm and caused this contamination, you've got to help pay the costs of cleaning it up. Because I've seen that over the years. This is now my 44th year doing this as an environmental attorney and several years before that as an intern. And if you ask invariably any generator of waste whether they would have paid a little bit more up front rather than having to clean up contaminated property like Ashland had to do up in the Martha oil field with the T-norm situation, invariably spending a little bit more to test things before you let it loose in the environment makes more sense than having to clean it up afterwards.
Thank you. Thank you, Mr. Chair.
Yeah, I've got a few questions, and as you can see, we're spending a lot of time here, and this is a very, very important subject, so that's why we're allowing all this time. Going to have a couple questions. First for Mr. Fitzgerald. What is if you can do this briefly?
Sure.
What is the current state of affairs federally, in your opinion, as far as PFAS? Where is it now, and kind of that chronologically, how long do we have before they ultimately make a decision?
That's a really good question. If you look at the EPA's website, they have a PFAS strategy. They are focusing first on drinking water, and then they're focusing on wastewater. They already have a guidance that they've done for the states that are implementing discharge permits that for certain SIC codes, certain industrial classifications, they should be testing and sampling the wastewater discharges. For some reason, sewage sludge is low on their list. So I think the way that this issue is going to come to the fore is that they're going to list PFAS as a hazardous substance under the Superfund law, and then they're going to back into situations where it has been released in the environment. And that's going to include some farms. We've got situations in Maine, they've now banned it. But this is one of those situations where it's going to be probably several years. And part of that depends on the political winds as they blow in Washington, how aggressively EPA is going to move forward. But the litigation that's occurred in the private courts, in the federal courts, over PFAS is in part driving it's driving the private market, and that may drive some of the cities in terms of their management of these wastes. I'm just concerned in the meantime that the farmers understand that there's a regulatory lag here between what we know, what we should be concerned about, and what the rules require But the cabinet has the flexibility. I just wish they'd gone further and required testing in those cases where we have reason to believe that there are contaminants of concern.
So if PFAS are found to be a federally recognized contaminant, what's your opinion on what happens at our water plants?
They're going to have to manage those. Hazardous substances are not quote unquote hazardous waste necessarily, but it requires a level of for your own protection as a city in terms of liability. You'd want to document and sample, enough samples that you have a pretty good cross section under high and low flow conditions, what the composition of your sludge is. You're going to manage them in a monofill where you totally control that landfill as a city, or you're going to send them to municipal landfills, which is what's happening now with a lot of the sludges. And Tony's absolutely right. Those of you familiar with Big Run and the problems we had up in Boyd County with taking New York and New Jersey sewage sludge, it took a while to get that under control. And there are odor issues, there are management issues, regardless of how you manage. But I think what you'll see is more use of anaerobic digesters, which is above ground in vessel management under anaerobic conditions where you're generating methane and then you're managing the waste to stabilize it, or you're going to see more use of landfills as opposed to land application. But at least you're going to see more screening.
My understanding is the new plants, our new water plants that are being built right now, they can filter for PFAS. Is that correct? Is that your understanding?
That's my understanding. Is that, yeah, and Tony can talk about that. That obviously is EPA is eventually looking back up the chain and is going to put more requirements on the industries that are discharging to streams and to sewage treatment plants. And to the sewage treatment plants in terms of their discharges. This is just an area that, at least in my estimation, they seem to have put low in their priorities.
Go ahead.
And Tom, I think one of the reasons they've put it lower in their priorities is because it's like this historic chain of how we manage this materials. It moves from one location to another in the loop. A lot of the sewage sludge that goes to landfills, they get it back in the form of landfill leachate. Right. So it's in this circle right now. But Senator West, you asked about the drinking water piece of it. So the drinking water piece of it is what EPA has clearly got at the top of their list of priorities now. That's what we as an agency has had at the top of our list as a priority. That is a problem that is manageable, technically manageable, as long as you have the resources to put those processes in place to remove the PFAS from finished drinking water. The land application issues, the potential Superfund issues, those are a lot more difficult, a lot more long-term. But clearly drinking water is their primary concern right now, and I think the reason the sewage sludge is sort of on the backside, they just don't know what to do with it. If you start creating breaks in that chain, you've got a waste that keeps getting generated, and what do you do? And it puts a significant burden on cities, obviously, because they're receiving it. And along the grand scheme of things, maybe folks who are producing it, things who are receiving it, the city might be in the least viable situation to address the problem. I think some of EPA's process moving forward is to try to remove it before it ever gets to the POTW or before it gets to the landfill. But in all frankness, that's a years-long process because the technology and the money has to be able to catch up to that. So those are just longer-term, real difficult issues to wrestle to the ground.
Yeah, we're discussing, the reason I'm spending a little time here, we're discussing this in budget now. What do we do with new dollars for water systems? Right. So we've had investments in mainly piping and those type of things. I'm advocating for we put more of that money into the pumping stations and the water plants to hopefully address some of this stuff. One more question, we'll be done. Pulling back from my law school environmental law class, never thought I'd be able to use these words. Could our cities be potentially a PRP if these rules are promulgated that it's a contaminant? Could they be under Superfund, CERCLA, a PRP?
I think they clearly could. We have under certain amendments to the Superfund law, we've exempted cities in terms of contaminated properties if you do due diligence and you haven't made things worse. Here, the cities are the generators of the waste that is being land applied, and if they haven't done their due diligence, they haven't sampled, and they haven't informed the farmers. I think there can be liability, not only common law liability, but I think there can also be statutory liability. Now, when if Congress steps in, they can change that. But if the PFAS or some of the PFAS family are listed as hazardous substances by EPA by regulatory action, that triggers potential liability for places, for people who generated, transported, arranged for disposal, and did the disposal.
Thank you so much. Any other questions from members?
Mr. Chairman, I just want to thank you and thank the committee for taking this time.
Thank you so much. And no matter what we do today, this will be a very, very important subject moving forward. Seeing no further questions and no motions on the floor, please call the next regulation. Thank you.
Merchant Electric Generating Facilities, 401 KAR 103005, 10, 20, and 30, all with staff suggested amendments.
401, 103005 through 103030, establish requirements for the monitoring and enforcement of provisions for merchant electric generating facilities, including establishing definitions, notification requirements, ownership transfer procedures, fees, reporting requirements, decommissioning provisions, and financial requirements. The amended after comments versions revise definitions, make technical corrections, revise the fee schedule to set a set fee of $6,000 rather than a fee scale based on generating capacity, revise incorporated material, revise liability and decommissioning provisions, and revise financial assurance criteria and processes. The staff suggested amendments amend various sections to comply with KRS Chapter 13A.
Would you please identify yourself for the record?
Tony Hatton, Commissioner, Kentucky Department for Environmental Protection.
Tyler Shields, Environmental Control Supervisor, Kentucky Division of Waste Management.
Luana Aldridge, Environmental Scientist Consultant for the Office of the Commissioner.
Thank you. Merchant solar. We're talking about solar today, correct? Any questions from members on this set of regulations? I'm assuming this is in relation to the bill we passed last year, carrying that out. I just got one quick question. On the $6,000, is that a one-time upfront, or how does that work?
That's an annual fee.
Annual fee.
That's an
Okay.
annual fee, yes, sir. And
So that merchant facility will be charged $6,000 every year as long as they operate?
Yes.
Okay.
Yes, sir, Mr. Chairman.
I was a little confused on that one. Any questions from members? I was reminded by my crack staff I forgot to adopt the amendments. There are staff amendments. Is there a motion for approval? There is a motion and a second. Without objection is so ordered. Any questions from members? Seeing none, please call the next regulation. Thank you.
Transportation Cabinet, Department of Vehicle Regulation, 601 KAR 12080 with staff suggested amendment.
This regulation establishes procedures whereby an applicant for a renewal or duplicate operator's license, or an applicant for an initial renewal or duplicate personal identification card who does not have an established and fixed nighttime residence may use a service provider's address as proof of residency, and establishes procedures for a homeless youth between the ages of 16 and 18 to obtain a personal identification card without the signature of a parent or guardian. The staff suggested amendment makes technical changes.
Would you please identify yourself for the record? Microphone. Green button there. Click on it.
Good
There
afternoon.
you
My
go.
name's Christy Walker, Director of Driver's Licensing.
Yes, Kyle Ray. I'm the attorney for the Kentucky Transportation Cabinet.
Thank you so much. There is a staff amendment. Is there a motion for approval of the staff amendment? We have a motion and a second. Without objection is so ordered. Any questions from members on this set of regulations dealing with identification? Representative Bridges.
Just a comment. I just want to tell you how much I appreciate you working on these regs after we got that bill passed. For the 16 to 18-year-olds to have a legal ID, to be able to apply for the first job, apply for college grants and applications, scholarships and everything. It's a very valuable and needed item for these. So I just want to tell you how much I appreciate that.
Thank you.
Thank you, sir.
Thank you, Mr. Chair.
Thank you. Any other questions? Seeing none, please call the next regulation. Thank you.
Cabinet for Health and Family Services, Department for Medicaid Services, 907 KAR 1061. This has an agency amendment.
This regulation amends to add 2 new services that can be provided by ambulance transportation providers: treatment in place and treatment, triage, and transport. It also establishes payment and mileage rates for those 2 new services. The agency amendment amends sections 22G and H to remove the coding system references and specify that the base rates shall be as consistent with the Kentucky Medicaid Transportation Fee Schedule. It amends sections 22H to add a new paragraph stating that the rates in subsection 2 may be increased as consistent with the fee schedule. Amends section 24B to specify that the upper limit is $3,500 or as increased consistent with the fee schedule. And amends sections 2, 2, and 4 to include the website address for the fee schedule.
Would you please identify yourself for the record?
Good afternoon, Jonathan Scott, Chief Legislative and Regulatory Officer, DMS.
Thank you so much. There is an agency amendment. Are there any?
Second.
We have a motion and a second. Are there any questions on the agency amendment? Seeing none, having a motion and a second, without objection, it is so ordered. Any questions from members on this regulation dealing with the Department for Medicaid Services? Seeing none, please call the next regulation. Thank you.
Department for Aging and Independent Living, 910 KAR 1170. This has an agency and a staff suggested amendment.
910 KR 1170 amends to update terminology and the scoring level form used by case managers to determine frequency of client contact. The staff suggested amendment amends various sections to comply with KRS Chapter 13A. The agency amendment amends Section 3 and 4 to reference home modification, amends Section 3 to reference natural supports and supportive service provider, and amends Section 6 to include that an abbreviation stands for an Area Agency of Aging and Independent Living.
Would you please identify yourself for the record?
Good afternoon. I'm Phyllis Sosa. I'm the Assistant Director of Quality Living for the Department for Aging and Independent Living.
Good afternoon, Edward Clark, Aging Services Branch Manager.
Thank you so much. There's a staff amendment. Is there a motion for approval of the staff amendment? We have a motion and a second without objection, so ordered. There is also an agency amendment. We have a motion and a second. Are there any questions on the agency amendment? Seeing none, seeing a motion and a second without objection is so ordered. Seeing no further questions, thank you so much.
Thank you.
Please call the next regulation. Thank you.
Department for Community-Based Services, 922 KAR 5070 with staff suggested amendment.
922 5070 amends Adult Protective Services provisions to prevent abuse, neglect, or exploitation, to revise investigative acceptance criteria, add a reporting deadline for cases that result in death, and make technical corrections. The staff suggested amendment amends various sections to comply with KRS Chapter 13A.
Would you please identify yourself for the record?
Good afternoon. My name's Laura Began. I'm the Regulation Coordinator for the Department for Community-Based Services.
Good afternoon. I'm Clifton Bryant. I'm the Branch Manager for Adult Protective Services.
Thank you so much. There is a staff amendment. Do we have a motion for approval?
Second.
We have a motion and a second without objection. So ordered. Any questions from members on this set of regulations dealing with adult protective services? Seeing none, thank you so much.
Thank you.
Board of Social Work, 201 KAR 23170. This has an agency amendment.
This regulation establishes directions and compliance procedures for social workers who use telehealth. The proposed agency amendment amends various sections to make substantive and technical changes and to comply with the drafting requirements of KRS 13A.
Committee will stand at ease. Would you please identify yourself for the record?
Mark Kelly, Executive Director.
Hank Cecil, Chair, Kentucky Board of Social Work.
Thank you so much. There is an agency amendment. Are there any questions on the agency amendment? Any questions on the agency amendment? Seeing none, we have, at this time, we have a speaker signed up to speak against. Would you all like to speak on the reg before we call up the speaker against?
Yes. Yes.
Please proceed.
We have worked diligently with the Children's Alliance, and the Children's Alliance presented us with 15 concerns, and we have whittled that list down to 6 concerns. So we feel like there has been progress made.
Okay. Thank you so much. At this time, we're going to have Mrs. Sanborn up. I'll allow Mrs. Sanborn to speak against. I'll allow the the board to respond, and then we'll open it up for questions. If you would state your name for the record and then proceed.
Chairman West and Subcommittee, I'm Michelle Sanborn, the President of the Children's Alliance. Unfortunately, the Children's Alliance continues to have serious concerns with the implementation of 201 KR 23170, the Telehealth and Social Work Practice Regulation. A list of 6 concerns should be in your packet, and I'm happy to walk through each of those concerns if the subcommittee would like. However, for the sake of time, I'd like to mention a few. The definition of telehealth service in the regulation is different than the definition of telehealth service and the telehealth terminology and glossary that is incorporated in the regulation. So I'm not sure if social workers will understand which definition to follow, because there's 2 different definitions of telehealth service in the regulation. The new definition that's drafted in the regulation, different from the glossary, seems to extend the statutory definition of telehealth by allowing any service provided via electronic means, without any parameters and guidelines to explain this expansion beyond the statutory definition, and in addition seems to expand telehealth to services beyond healthcare. The Children's Alliance again asks that healthcare be included in the definition of telehealth, which is consistent with statute and the glossary. And if the Kentucky Board of Social Work is authorizing clinical social work to be provided by all electronic means, that includes email, text, fax, artificial intelligence, per KRS 211-332, we would ask that the language be included that this regulation indicates these modalities are only to be used to enhance recipient health and well-being and meet all clinical and technical guidelines for recipient safety and appropriate delivery of services. 2, requiring all licensed social workers to use encrypted text messages and emails for all communication with clients seems very overwhelming for our social workers and their employers, not to mention the clients, to implement. The Children's Alliance would agree that if teletherapy is being provided via text and emails, that encryption is necessary. However, requiring all communication to be provided via encrypted text messages and emails seems unnecessary and very costly. So if a social worker for a foster care agency sent information to a foster mother about her foster child's upcoming appointment, they would be required to use encrypted email. 3, some of the requirements in Section 2 should be required each time a social work service is provided via telehealth to a client. It's a matter of safety. while other requirements in Section 2 should only be required upon initial contact or periodically thereafter. We recommend that requirements expected to be performed at each telehealth or social work service encounter be separated from those required that could be performed one time or periodically thereafter. According to this regulation, a case manager is required to assess and document that the client's needs are appropriate for services each time they talk with a client via telephone or via email. They're required to obtain written informed consent each time they talk with the client on the telephone. And how can a case manager obtain written informed consent when they're emailing or calling a client? Thank you again for listening to our concerns. The Children's Alliance does not believe it is in the best interests of the general public and those regulated by the Kentucky Board of Social Work for this regulation to proceed forward without addressing these concerns mentioned. I'm happy to discuss the other three. However, for the sake of time, I'll turn it back over to you.
Thank you so much. This time we'll kick it back to the board if you would wish to respond to those comments.
Those are the remaining issues, so we would be glad to work with them on that.
Okay. Any further comment at all?
We can defer.
Okay. I'm going to open the floor up for questions. Do we have questions from members? Senator Adams, do you have a question?
I don't necessarily have a question, but I do have a comment, and that is we have, I think, been crystal clear in our desire to have the board work with all of the providers to fix these problems. And each month we come back and it has not been fixed to everyone's satisfaction. You know, there is compromise. It can be had. It's not a difficult place to be. We try to find that place every time when we discuss different bills that come before us. So at this time, I would like to make a motion for deficiency.
Second.
There's a motion of deficiency on the floor with a second. Before we act on the motion for deficiency, I do want to allow any other member who has a question or concerns on the committee to ask those at this time. Representative Grossberg.
I have a few comments, but beforehand, I have a question. It is my understanding from emails with the board that the Children's Alliance is the only organization that has reached out with staunch opposition and that you've heard from a number who are supportive of it. I have not received such emails or phone calls. Could you share with the committee who are these other organizations that have reached out in support of the proposed regulations?
Well, we've spoken to 2 child welfare providers and 6 of the community mental health centers. And unfortunately, because of the nature of what's happened, I don't have their direct permission to reveal who it is, but I can seek that for you if that's necessary. But I know one who would probably not, is kind of more allowing me to say yes, that they said they're okay with it, is Four Rivers Behavioral Health.
I'm sorry, which one?
Four Rivers Behavioral Health.
Okay.
Please proceed.
I wish that we weren't at this point that we're at with month after month after month of delay. I'm glad that we are now seeing an opening to working together and compromising. Unfortunately, I'm sure you're aware that we only have, I think it's 11 days of session left after today, and that there is a bill in the Senate, which, if I understand correctly, Senator Rocky Adams is the sponsor of, that would address these concerns with what is almost inevitably going to be a successful finding of deficiency. I just wish that we'd gotten at this process earlier, because in the absence of legislation, regulatory change is the only thing, and we're not in session again until next January. And as much of a fan I am of this governor and the relationship that I have with the speaker and the Senate President, which I believe to be good, I can't imagine them all agreeing that we're going to come in here and have a successful special session to address this legislation. So I do hope with what as I said, I believe is soon to be an inevitable vote, that you work together in earnest so that we don't hear about anonymous, mysterious organizations that support it, but instead hear openly that every organization is in support of the legislation that we are soon going to hear.
Just to give it a little bit, it's kind of like, I think sometimes there's a miscommunication over this issue of informed consent, that it's done every time versus not. And that's kind of where we're stuck a little bit, of trying to explain that it's not every time, because the reg, as we've written it, doesn't say every time. It's open. But we keep hearing from them that it says every time, and we don't understand it that way. And that's part of the issue. It's not because we're not trying. It's just that they keep saying it's every time, but the way we wrote it, I mean, our attorney, it doesn't say every time, like for an email or a text. And that then there's another section in there that says that, you know, a person, the client and the case manager in this case, could get non-secure communication and agreement for that. And there's some free apps even for encryption if they chose the encryption route. So it's not a costly venture, and it seems to be some miscommunication about that piece. And that's the hard part about working at it. And, you know, we're willing to continue to do that, to keep that. And it's not like it's impossible. It's just, and we didn't get to come here in February because we had to take some issues back to the board, which met on the same day as this committee. So, you know, that's why it's been that way. So it's that kind of effort that we're doing. We're trying to as best we can. And again, like I said, it's just some miscommunication because the board can't, board's got an attorney to advise us and looks at it and then advises it, well, it's not written that way. So, well, why is it, you know, so we're still struggling with that. And I just would have to ask for the patience of you all for us. One of the challenges of being able to overcome that. And we just haven't had the time. I'm a volunteer. The volunteer board, we're struggling with that. And if we could have some time, I really do think we could work it out. I have a more hopeful point of this than when I was here in January.
Representative Grossberg.
Mr. Chairman, I'd like to hear what the Children's Alliance has to say. I can read body language and then I'll make my comment.
You read my mind, Ms. Sanborn.
We have not met or spoken to the Board of Social Work around this reg since January 3rd. There's been communication via email around this. I've asked on numerous occasions to meet with them. We scheduled a meeting, which they declined. I asked to go before the board, but obviously I didn't ask, I guess, ahead of time or enough days ahead of time because I didn't know, because I didn't realize it was going to be on the agenda. And so I was told I could attend but not speak to the board. So I've not spoken to them about this. I've only provided the same comments that I've provided back in September about the ability for this reg to be implemented. The regulation says upon initial contact with a potential client and with the client thereafter, all licensees using telehealth to deliver telehealth services, teletherapy, and electronic social work services shall, we go down to letter, I guess it's G now because there's a lot of cross-throughs, obtain written informed consent for telehealth, teletherapy, and electronic social work services. That includes, and it marks. That's what the regulation says.
Thank you. Any other questions from members on this? I think I'm going to cut it off here. I think we've had ample discussion on this topic. Seeing that there is a motion on the floor for deficiency and a second, having had the discussion, the question is on the motion to find the regulation deficient. All those in favor of finding the regulation deficient will vote aye. Those opposed will vote no. Please call the roll.
Senator Rocky Adams. Senator Thayer.
Aye.
Senator Yates. Representative Bridges.
I will be an aye. May I explain my
Please
vote?
proceed.
You said September. I believe there was a month before that this went into operation. That's been 6 months. You are saying you feel like you could easily work this out, or there's a chance to work it out. And by the time we do that, I feel like we're going to be next September, which would be a full year. And you have been asked a number of times, all the way to the point to where both in the House and the Senate bills were forced to be filed, and this is unacceptable. So I'm going to make one suggestion. I don't know about the rest of the committee, but I'm exasperated over your refusal with small excuses, whatever, that you can't, you will, you won't, whatever, but just give us more time. Time's ran out, gentlemen, and I would suggest in the future you be more willing to make yourself accessible, not just to the Children's Alliance, but any of those that fall underneath your purview, to be more willing to work with them and make yourself more accessible. Thank you, Mr. Chair.
Representative Frazier Gordon. Representative Grossberg.
Permission to explain my
Please
vote.
proceed.
I don't like having to make this unanimous, but I'm going to have to find deficiency. I believe that you have tried relentlessly, but we have not seen the progress that is necessary. And if we don't find this regulation deficient, which, as I said, I think the votes are there, we're going to be stuck with something that is found unsatisfactory on the record by a major agency with no one on the record finding it satisfactory. So I plead and urge that you use the remaining few days before the final version of the bill that Senator Rocky Adams has proposed is heard to find something that can leave you at least a little bit happy. And I am therefore an aye on the finding of deficiency.
Representative Lewis. And Senator West.
Aye.
The motion to find the regulation deficient has passed with 7 votes.
Thank you. The regulation is found deficient. This being the last order of business to come before this committee. Before we adjourn, do we have any comments or announcements? Seeing none, this meeting is adjourned. One moment. Committee will stand at ease.
Next meeting.
We chose specifically not to vote on the amendment. I was checking to see if there was a reason to vote on the found.
Thank you.
Any comments on the next meeting?
April 8th, which is a Monday at 1 p.m.
Thank you so much. Seeing no further business, this meeting is adjourned.